Hello friends, and did you know in the United States there are only a handful of community property states, which means in those states the couples usually hold assets jointly with very few exceptions. So today we're going to talk about the differences between community property states and equitable distribution states. Welcome back to the Divorce Broadcast. My name is Manny Segarra, coming to you from Miami, Florida. Let's talk a little bit about community property. In community property states, all property acquired by either spouse during the marriage is considered joint property, regardless of who earned it, who earned the money, or whose name is on the property. Separate property is only property that belongs to them individually. Usually, the separate property refers to anything that the spouses acquired before the marriage or either after separation. It could also include any gifts or inheritances that either spouse received at any time individually in their own names. There are some exceptions, so you have to look at the rules of these community property states. But when it comes to divorce, when it is a community property state, it means that the property is usually divided equally between the spouses. Each spouse is granted 1/2 of the community property and is entitled to 1/2 of the value of the entire community property. All right, let's talk about equitable distribution. In the equitable distribution states, including Florida, where we're currently filming, property acquired during the marriage is not automatically considered joint property. Instead, the courts of these different states may consider a variety of factors such as the length of the marriage, each spouse's income and earning potential, and the contributions of each spouse to the marriage. In equitable distribution states, the parties' separate property may be considered separate unless they share it or the separate property gets commingled into the marital estate. So that may make what was previously a non-marital property into having some sort of marital component, depending upon the circumstances and the state. Also, under equitable distribution, the courts, and this is the important part for purposes of divorce, the courts may divide property in a way that is not necessarily equal, but is considered fair based on the particular circumstances or specifics of that particular case. That means that a spouse may receive a larger share of the property than the other. So that's where in these equitable distribution states, these properties aren't divided equally and someone may get more. In summary, just to kind of compare the two, community property divides marital property equally, while equitable distribution takes a more flexible approach to dividing marital property based on what the court considers to be fair and equitable under the circumstances. That's a lot to ponder. As I mentioned in the intro, there are very few community property states in our country. So can any of you venture a guess as to how many there may be? Well, for those of you who answered 9, you are the winner. There are officially 9 community property states as of the date of this recording. Most of them are in the West Coast, and then there's one in the Midwest. They include the states of Washington State, Idaho, California, Nevada, New Mexico, Arizona, Texas, Louisiana, and Wisconsin, which is the one in the Midwest. So it's a very interesting variety of states that still follow the community property statutes. Now, whether you live in a community property state or an equitable distribution state, whenever there is an asset in a divorce case, the 4 steps are the same, no matter which way the state follows. The first is the identification of all the property and the assets. Where is the property located? What is it? Is it tangible, intangible, like money or some sort of intellectual property? This can be anything from a house, a car, a boat, crypto, all of that stuff that we've done videos on before. The second step is classification of the asset. Specifically, when was the property acquired? If the property was acquired prior to the marriage, in a community property state, it's out. If the property was acquired prior to the marriage in an equitable distribution state, well, let the games begin, because it may be marital, there may be a marital component if there was a commingling of marital funds with that asset or property that was purchased before the marriage, or maybe there was some enhancement based upon the non-owner's spouse efforts and labor. So that's where the fight sometimes occurs in equitable distribution states. The third step is the valuation of the subject property. So a lot of times the property has to get valued. Think about a real estate appraiser valuing a home, or think of a business valuation when the asset or property is a marital business. The fourth step is where the states diverge. The fourth step is the distribution of the asset or property. The court will distribute the asset or property based on the statute of that particular state. That means that in a divorce in a community property state, the property or asset will be divided equally. Under the equitable distribution statute, the court may divide the property equally, or it may be divided not necessarily equally. So that's a wrap on community property versus equitable distribution states. I hope you found this information to be helpful. If you know anyone living in Florida who may need assistance, we are an equitable distribution state. Just to remind all of you, have them look us up at www.segarralawfirm.com. We have offices in Miami and Orlando, se habla español. If you enjoyed this video, please hit the like button. Share this video with any friends and family that are dealing with the distribution of assets in their particular state. And please consider subscribing to the Divorce Broadcast. Thank you.